Gun rights lawyer Matt Larosiere weighs in on the two big National Firearms Act lawsuits. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm a CNN contributor and the founder of thereload.com, where you can head over today if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news and analysis. This week, we are going over the two major challenges to the National Firearms Act and its regulations of silencers and short barrel rifles and shotguns that have come out of the change to that law that Congress passed just last month. We now have both of the big coalitions of gun rights groups put out their text. And so we want to go through it with somebody who is knowledgeable on the topic, but also independent from those groups. Doesn't work for one of them. It's always good to have on groups that are involved, but it's even better, I think, to have somebody independent come on. And that person today, this week, is Matt Larosiere, who's a gun rights lawyer down in Florida, who has done some work for some of these groups in the past, but is an independent lawyer down there, and who also runs the YouTube channel Fudbusters. Welcome back to the show, Matt. Thanks so much for being with us.
Always a pleasure to talk to you, Stephen.
Yes, and now you have worked with some of these groups, because I think probably every major national gun rights group is pretty much involved in one of these two suits. There's Gun Owners of America.
Almost.
Yeah. Well, I guess not. But there might be one or two missing. But
yeah. Interestingly, one of the highest funded ones is missing, which is kind of funny.
I guess National Association for Gun Rights, I don't think, has joined one of these two. I don't know if they're going to do their own or what.
Who knows
what they're up to? But yeah. We have Gun Owners of America, the FRAC, the Firearms
Regulatory Accountability Coalition.
There it is. Sort of an industry group. You have a number of major gun retailers and silencer makers like Silencer Co. and Palmetto State Armory.
You're in Tomet.
Yes, they're all involved in one suit, which we can just kind of call the GOA suit. And then more recently, we got the text from the National Rifle Association, Second Amendment Foundation, Firearms Policy Coalition, and American Suppressor Association lawsuit. I think there are also a couple of gun companies involved in that one. And then, of course, there's individual plaintiffs in all of these as well. But you have two big coalitions of coalitions, right? And you've done some work with these, with a couple of these groups in the past, right?
Yeah, for sure.
And so you've also filed cases that are similar to the claims in these two suits as well, right?
Correct. Yeah. I've, in the past 3 or 4 years, I've brought 3 such claims under the tax and spend clause analysis.
Mm-hmm. And so you should have a pretty good, I think, insight into how this may go, or at least you have some experience in this realm here because we're kind of wading into tax policy in large part. Now there is one of these cases, the NRA case, does have a Second Amendment component to it as well. But the primary focus here is on the tax argument. Can you just sum up maybe what the two groups are arguing, or groups of groups are arguing here?
Right. So it's very interesting. So first, I'm going to just tell you what the two cases are and what their claims are. And then I think after that, I think we should talk about what it takes to properly state those claims under the precedent. And then we'll kind of talk about how that all shakes out. So the one that you call the NRA case, it's brought by Kirk as the law firm.
Yes, that's a big law firm that does a lot of these Second Amendment cases, right?
Correct. That one is a 2-count suit. Count 1 claims that the government has exceeded the scope of its authority under the tax and spend clause. And count 2 is that the regulation of SBRs and silencers is a violation of the Second Amendment.
Although not short barrel shotguns, right?
Right. And there's some interesting wiggle wording that goes on. as we were talking earlier, you noticed that they indicated that silenced firearms, right?
Yes.
They're trying to kind of like ring fence their reading to avoid questions of whether or not something is or is not an arm. So there's a lot of funny legal games being played here, but try not to let that take away from the big picture. So the Kirk NRA case, 2 counts. Count 1, you've gone too far. You've exceeded the scope of the tax and spend power. Count 2, regardless of that, what you're doing here is a violation of the second.
Mm-hmm. Right.
So then on the other side, and that's been filed up in the 8th Circuit, I believe, Missouri. Then GOA brings its case in Texas.
5th Circuit, yes.
5th Circuit. They have 2 counts, but they're both pointing at a tax clause problem.
Mm-hmm.
And basically, what this all relates to and what both of their averments point to is the big, beautiful bill eliminating the $200 tax on making or transferring a suppressor, short-barreled rifle, or short-barreled shotgun. Basically, they've eliminated the taxes that individuals generally pay under the NFA for everything except destructive devices and machines.
They've made it $0. I guess that's one of the questions here, is making the tax $0.
That's very
eliminating it, right?
Yes, because they haven't eliminated the tax. There is imposed and shall be collected a $0 tax.
Right. It sounds strange, but that's how it works mechanically.
And that is what the law says. And so that's an important point. And this is kind of going to come up later, because that'll be an important point of analysis: is the tax eliminated, right? But yeah, as the law is written, there shall be levied and collected tax of $0. So that's kind of where we're at with respect to the 2 suits. And they're both they're alleging that the basic argument in both cases is, hey, you're not collecting any tax. That makes it completely not a valid exercise of the tax power. This is unconstitutional. You got to knock it off.
Right. Because the NFA under this has been justified in Congress. Both when
and it's one of the rare cases where the government was express about its source of power.
Yeah, they said it explicitly when the law was passed.
And repeatedly disclaimed the commerce power. They said, no, pure tax.
Right.
And they've said that in litigation too.
As well, yes.
Yeah.
So it's not like these guys are basing this idea off of nothing. And certainly, and you've brought similar claims to this in the past. Essentially, it's a tax. Now the tax collects no revenue. So at least for these certain sections, it's no longer really a tax. And so if it's not a tax, it can't be justified by Congress's taxing power. Mm-hmm. So it's unconstitutional, right? That's the basic breakdown for both of these.
And that's the 1,000-foot view. But of course, the devil lies in the details. One thing you have to understand is that pretty much the reason we have limitations on federal courts is because the framers were super concerned that every single tax was going to be challenged at all times. And so...
Well, it is America, and that is...
Yeah. And so it is very difficult to challenge a tax. So when you're challenging something as an exercise of the tax power, you have to pass 2 steps. Okay. First, you have to actually articulate a taxing... No, sorry. I was reading from the wrong section of my note. First, the taxpayer has to establish a logical link between his status as a taxpayer and the type of legislative enactment that he is attacking. Now, this can be met by simply alleging that, hey, this particular law that you're doing is unconstitutional, specifically because it is beyond the scope of the tax and spend clause. Second, so you can get through that by saying, hey, this particular law, it goes beyond the scope of the tax and spend clause, and so you are without power to do that. Second, you have to show that the actual law that you're challenging exceeds specific constitutional limitations imposed upon the exercise of the tax and spend power, and not simply that the part of the law that you're challenging is generally outside the scope of Congress's power. And so the courts have specifically held for over 100 years that this is not met if you're challenging the effect of an act rather than the act and its structure itself. And this poses a lot of problems. And so basically what we're getting at here is, are you actually challenging that this particular thing is a tax? Okay. It's harder to do than you might think.
Hmm.
The most illuminating case we have for this is Selius, NFA v. Selius, the Obamacare case.
This, by the way, that's was the Obamacare individual mandate was something that was also key in the how this law played out in Congress. So yeah, it does seem to be a very good analog, certainly in the legislative part of this fight, and now it appears it's coming up again here in the legal part.
Yes, it's all full circle, right? It's a very important case, and it was never lost upon legal scholars when it came down that we were going to be talking about Selius for a long time. So they articulated and very clearly pointed out the functional approach to whether or not something is a tax, right? And this proper exercise of the tax and spend power, or more like a criminal penalty. So there's three factors that you look at, and you'll see that these are all looking at, is this closer to a normal tax, or is this closer to something that would ordinarily be treated as a crime? And the touchstone for this was the child labor law cases, which were very suspect. They were struck down as an unconstitutional exercise of the tax and spend power. And the things that were really important to the court in the child labor law cases is, one, the severity of the fine. That was 10% of the company's total gross revenues, regardless of how serious, it's like one kid or 20 kids, right? It's a severe penalty. And so a severe penalty tends toward not a tax.
And so that was like a case where they tried to tax companies that employed child labor as a sort of way of
getting
child labor.
Well, and we'll get to that in the third factor, right? But so yeah, this was something that was purported to be a tax on the use of child labor, which was already illegal. So number two, does it have a scienter requirement? And scienter is your criminal knowledge. So do you knowingly do the thing that requires the tax? The labor law case, it only applied to those who knowingly violated the child labor laws. So that's, another touchstone. If it's knowing, it's more like a crime. And finally is a question of how the tax is enforced and collected. So, and this is where people, a lot of people get excited in the gun context, because the touchstone in the child labor law case was that it was the Department of Labor who was doing this, and they don't collect taxes. And so you might be quick to say, oh, so that one's in our favor. Well, the way it was done in that case was kind of odd, in that the labor inspector had the authority to just invite IRS agents whenever he wanted. Well, not IRS, but revenuers whenever he wanted. And so there's this weird cross-pollination that was just kind of bizarre. And it was observed that the true effect of that was to enable punishment for some third policy that wasn't actually being investigated by the Labor Department, right? And so number three is, if it smells more like criminal enforcement, it's probably not tax. And it's not, we know that one alone is not enough. So you have to get either two or three of these. And ideally, if you want to succeed on a tax challenge, you want to hit every branch of the way down. So you might be putting together, it's going to be hard to do. And this isn't me saying, and let me just make clear, this isn't me saying that there's anything wrong with these challenges. I think these challenges to the NFA are totally consistent with the spirit of the Constitution, totally consistent with spirit of the law. That said, when you're in federal court, it's not about the spirit, it's about the letter. And there's a lot of case law that makes it a big challenge to successfully bring this type of case.
Yeah. And I guess that's part of the difficulty too when you're a gun rights group using people who have more experience in Second Amendment litigation to do a tax law challenge, right?
Right. And
so there's some specifics here that you think could be a problem for the way these cases have been pled on
for sure.
Those 3 points.
So absolutely. And so we have to get through the 2-step, and step 2 of the 2-step involves, have we met these 3 points, right? So it's kind of a two-step analysis, which is frustrating, but I'll try to keep it as straightforward as possible. The real problem with the way these were brought is, and I take a little exception to the messaging on these cases, because they were saying, oh, this is groundbreaking, first ever historical challenge to the NFA. It's not true. And I'm not just talking about the cases that I've brought over the last 5 years. The first tax and spend clause challenge to the NFA was brought in 1937.
Right. They cite that one in the GOA case.
So right? it's not groundbreaking. And it's an argument that's consistently been brought. And we've got decisions on point from just about every federal court of appeals, kind of struggling with the issue. It's never a clear gong ringer, right? But this is a thoroughly litigated area. Not to say that it couldn't use more, and not to say that I'm not saying that I don't agree with the way they're bringing this, but just going to point out that
these aren't necessarily new arguments that we're seeing in these cases.
Exactly.
Although obviously the argument here is that the change in law gives you sort of a catalyst to retry a lot of these arguments, and maybe you'll have a better chance, right? That's essentially how I'm looking at it, at least. So certainly the way that, you could criticize the way that gun rights groups fundraise off of lawsuits like this, or like any of the lawsuits that they do, or any of the lobbying they do, because fundraising in politics, it's not just the gun groups, but they certainly engage in it, is often very misleading and often will lack a lot of context and nuance of what's really going on in an attempt to just get attention and money. There's certainly ethical criticisms you can have of that, which I know you have raised over the years, certainly
incessantly.
But certainly very fair point, I would say, on that regard. Sometimes, I've gotten fundraising letters from the NRA that are clearly designed. They talk about how that you're on this list, and if you don't you don't give
$250 by tonight, the list is going to get published to North Korea or something.
Just like the implication is, they're not saying it in the fundraising, but the implication of the fundraising, if sent to somebody who's maybe a bit older and doesn't know what's going on, is the implication is that if they don't do something, if they don't do what the fundraising asks them to do, which is give money to the NRA, that they'll be on a confiscation list.
Right.
And it's like deeply unethical, in my opinion. I haven't seen one of those in a while, so perhaps the NRA has changed tack on how it's doing that.
I saw one fairly recently from GOA. So
all these groups have engaged
notice
in
of confiscation or something.
Yeah, they've all and like, if you read it, it's not literally telling you that you're, if you don't give us money, somebody's gonna come and take your guns, but it's. We've all seen fundraising.
Right. I can't tell you how many times, for example, when I worked at one of these 3-letter groups, they would ask me to sign this email, and I didn't even get to read the prose. And then I see it go out, and it's a critical funding deadline for this lawsuit. And it's like, if we don't get X amount of money by this time, we're going to have to, we will have to face a critical strategic decision. It was completely made up. It's just it was total nonsense.
Anytime you get any fundraising or appeals from any group, honestly, it's probably just lying to you.
Which is, it's just awful, because the funny thing is, as gun rights activists, we're in a position where the truth is on our side, and we can just I feel like we can be transparent and both win and be ethical. But there's like some kind of pathological barrier that prevents anyone from doing that.
Yes, and to be fair, again, it does extend beyond the gun groups or even just this side of the gunfight. The gun control groups do similar stuff too.
Also, to be super fair, I can understand the narcotic effect because when I was at high level in one of these groups, I saw what the numbers looked like after you would send out one of those lying emails, and so it's
there's a reason they do it. It's
very narcotic for them.
It bleeds over into a lot of things, including media, news media outlets. Just lie or hype things beyond reason as well for similar
my
purposes.
main concern is I do think eventually you're going to fatigue people, and I can't believe we haven't done it yet.
Yeah,
but all that said, I think
at a certain point people would catch on to what's going on with this.
People catching on, that's impossible.
But anyway, so beyond the critique of how perhaps some of these groups are marketing this lawsuit, you all like the core argument here is something that you have yourself engaged in with the NFA.
Yeah.
And there is this idea that, Congress has made sort of the tax argument even more kind of a fig leaf than it was before, which it kind of always was, right? I mean, certainly this is a common opinion among gun rights activists that
it was an express fig leaf. They're like, we're doing this on purpose. We're not touching you.
Right. Like the tax and registration thing was really just there to try and ban these effectively, because the tax, when it was instituted, was effectively it would have been similar to a $5,000 tax today. Now they didn't pin it to inflation for whatever reason, so it's become less of a burden over the years. But it's fairly obvious that Congress was just trying to ban these devices, or at least severely restrict their use. And they just came up with this tax and spend excuse as a way around, which maybe, goes to one of the points of the three that you were getting at, that the purpose was not really tax collecting. And that's always been the critique of the NFA. But now Congress has, and again, I think this was part of the strategy in enacting these changes from Republicans. Certainly I talked to sources on the Hill that said, this will make it easier to challenge the NFA if we make these taxes $0 instead of $200, because then it really strips away this argument that it's a rightful exercise of the taxing power. So, what do you think is going to happen here?
If you have a very sensitive judge, I think it could get you pretty far in the district court. I don't know how it then gets reconciled with decades and decades of precedent is the problem.
Yeah, because none of these other challenges, like you said, they've been maybe close calls, but the NFA still exists. It's still here.
It is.
They haven't been. This argument has not been successful to this point.
And so let me kind of tell on myself. This makes the amount of sense that the challenges as these are brought makes deteriorates the more thoroughly you read the Obamacare case. So if you just kind of look at the ultimate holdings, which is, this is actually, in effect a penalty, and so it's not a proper exercise of the tax power, you'd be like, duh. But then you actually look at the approaches, right, and see how it's measured, and you see that you've still, like, maybe it took me and Ivan, my co-host on This Week in Guns, were talking about this, because he was asking, well, how do you think this has affected the tax problem? And I said, well, it's made it the tax argument easier. And then he said, by how much? And I said, a grain. Like it's moved like one grain off of the mountain. So that'll
because judges were already pretty willing to accept the idea that the $200 tax was not.
So let me explain. Let's go through the Kirk cases analysis and apply these points and kind of see where the hang-ups are. Right. So Kirk's case, this is the big one that has the two counts that includes the Second Amendment count.
The NRA case is another one. I mean, yes. I don't want to be like, hopefully no one gets upset from any of the other groups that are involved. It's a big coalition case, but
which is why famous group. This is why I was trying to use the law firm name and not the
fair.
It's everyone. So insofar as that case's tax analysis goes, it focuses on the elimination. It focuses on the change to $0 of the making and transfer tax.
Mm-hmm.
Here's one problem. Neither of these cases at any point mention the rest of the tax regime.
Right.
There's still a $200 transfer tax on machine guns and destructive devices and also other stuff. But here's the other big thing is that manufacturers and importers have a $500,000 yearly tax. And the transfer taxes are part of enabling components of the overall tax structure. The fact that they have ignored the remaining tax structure leaves that's a big flank to be attacked if the government is to thoroughly fight this.
Right. We had a couple of experts. We did a piece where we spoke to a number of Second Amendment advocates, professors and lawyers on either side of the debate. And this was one of the critiques that was brought up. Essentially, the NFA is still collecting tax revenue. These particular sections of it aren't necessarily, but the overall law certainly is. And so it kind of comes down to whether a judge is willing to bifurcate these particular items from the rule that now have the $0 tax. And honestly, this wasn't brought up, but it does bring to mind the fact that AOWs, any other weapons, right, which were also affected by this tax cut, they always had a very low amount.
$5.
Yeah, $5 from the very beginnings. That sort of a strategy that could have been used a long time ago, I suppose, in this regard. But anyway, I mean, it comes down to it. I guess one of the hurdles they're going to have to overcome is this idea that, well, not all of the taxes are gone. The NFA as a whole still collects significant. I mean, not significant in the federal budget percentage terms, but in real dollar terms,
like to be a tax. And then we'll get into some of the other issues later that you guys might be thinking, because they're rational things to think, right? And I'm just going to stress again, I think that they're right. I think this is how it should be, but I don't think that means they're going to win on it. Right.
There's a lot of hurdles to overcome here.
But even just like that, just the manufacturer and importer taxes were recognized as recently as 2018 in the 10th Circuit, where they kind of slapped down quite a few counter arguments in United States v. Cox, which challenged this as an exercise of tax and spend power. And Cox tried really hard to hit every branch on the way down as well. But so there's that problem, right? Is that they're only covering the make and transfer as applied to the individual and individual firearm, but they're ignoring the rest of the tax scheme, which very much still exists.
They don't discuss that in the suit at all.
They rightly discuss from all the way ab initio, right? They bring up the testimony of then Attorney General Cummings, like very expressly saying that this is just a tax and we cannot simply ban these things, blah, 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 right? And they make a lot of really interesting points about the commerce power without ever bringing a Commerce Clause claim.
Yeah, but that was the other big thing that a lot of the experts we spoke to brought up as a major hurdle is, like, even if you win the tax argument here, which is going to be difficult from everything you're describing, you still have the problem that the Commerce Clause power exists and has been greatly expanded since 1934. The Supreme Court's interpretation of what Congress can do under that authority is pretty broad. Now, as you mentioned there, that the NRA, GOA doesn't wrestle with this in their suit at all.
No, they don't wrestle with much of anything in their suit.
And they can amend their suit, right? I mean, this is another thing. Like, you're identifying some of the weaknesses in these arguments. Both these cases could be amended to address some of this stuff.
They probably will be amended at least once.
Okay,
and maybe they'll watch this. Who knows?
Yeah, maybe they'll take some ideas from your critiques here. But
yeah,
but the NRA does anticipate the second issue, which is that Congress could just say this is part of
that's
our
an interesting
Commerce
thing,
Clause
right?
power.
And so a lot of your audience is probably familiar with, the problem of Commerce Clause, right? And so what the NRA has done by mentioning all these issues with using this law under the commerce power is kind of preempted a savings argument. But here's the really weird thing. is that the NFA is kind of unique in how aggressively the government says this is just a tax law. And when we go to find a source of power within the Constitution for an enactment, because that's the first step in evaluating the constitutionality of any law, is finding a legitimate source of power for the law. You look to the legislative history, and the legislative history is, you go to legislative history before asking the government what they think now. And the legislative history is devastatingly clear with respect to this. It could not be clearer. And so the question is, and this is an open and interesting question, is can the courts say, in spite of the legislative history, in spite of the clear intention and invocation of the government, I'm going to find that it is an exercise of the commerce power? Am I going to be honest? Do I think the Supreme Court would uphold something like that? Yeah, I think they would.
Go back to that Obamacare case. A lot of people were pretty
because remember, it stayed up.
Unhappy about
the advantage stayed up.
Yeah,
it wasn't a tax, but it was, they ultimately determine it. It regulated inaction. Something.
Yeah, well, I mean, and they've been, the court certainly is famously in the New Deal era, the switch in time that saved nine, right? They were famously expanding the Commerce Clause power to regulate even things that don't have anything to do directly with interstate commerce. That was the what is Filler B? Oh man,
the big one is Reich, right? I'm growing weed just for me.
Yeah,
I don't want anyone else to touch it.
I shouldn't have tried to say the name of the case off the top of my head because I can't recall it. But Filbert, oh man,
Wickard.
Wickard, clearly butchering it. But either way, yes, the idea, the core holding in that was even growing wheat for yourself on your own property that never gets sold into the market is still has an impact on interstate commerce and therefore can be regulated. So under that logic, now obviously there's been almost 100 years of case law since then, and it's not quite, I think, as expansive as it was in that case anymore. But we had Charles Cook from National Review on that's one of his big bugaboos is the Commerce Clause expansion. And we did have the court actually strike down a gun law once over the Commerce Clause, the School Gun-Free Zones Act. They fixed it by just changing the language a little bit. And it hasn't been back to the court since.
That has moved or traveled in interstate commerce.
Right. So now it hasn't been back up to the court since. I guess we don't know exactly how this Supreme Court would address it, but they don't seem to be this court, the Roberts Court. They don't seem to have the Commerce Clause over expansion as a major concern of theirs.
Only Thomas cares.
Yeah, right.
But,
which is not
for those of you guys who don't know, the case we're talking about is Lopez, which is I think it's Lopez. I'm really bad at case names, by the way.
Yeah.
But it was the Federal Gun-Free School Zones Act, which just said you can't have a gun within X feet of a school. And the court struck that down as a violation of the commerce power. And so they literally just said you can't have a gun that has moved or traveled in interstate commerce.
Right. they wrote in a commerce justification. And I don't know, that never got struck down again. So I guess that was enough. It hasn't been back to the Supreme Court again. So you never know. Maybe if a challenge did make it up there, they would do something. But as it stands now, that law is still good law. That's what we were talking about in that podcast. If people want to go back and listen to some of Charles's insights into or his opinions on it. But yeah, so Commerce Clause is a potential, I guess, a deus ex machina for this law.
Yeah.
If it does.
Potentially the government could be like, you're 100% right. Anyway. So that's the risk of the Commerce Clause there, which is kind of like what happened in the Obamacare case. You're 100% right.
Yeah,
anyway.
That's more or less how the Supreme. That was what made that case so controversial.
Yeah, you're right. That is not a tax. Have a good one.
So that's certainly, I think, a real possibility here. Not a guaranteed outcome, but a real possibility that's something else the federal government can fall back on. It's like, well, fine. Even if you don't think this falls in the taxing authority anymore, we still have this other authority that we can point to.
But insofar as assessing the tax cases, right, we kind of I kind of gave you my broad level things. I think the NRA case does the first step of articulating a tax and spend challenge because they do have a heading. As a heading, they say this exceeds the authority under the tax and spend clause. I'm not sure if the GOA has really done that. I think you'd have to be wiggling a little bit to say they did. That said, they did admit that this was written in 24 hours.
And they can amend it.
They can amend it, which would be a wonderful use of time.
So you
take with that information whatever you will.
You see some flaws in just the way that they've argued the case, not just the macro argument, but how they've actually filed these two cases.
Yes, I don't. Let me just say this. I think that the NRA has done a pretty good job. The NRA case. I'm really struggling with this because I don't want to call it the NRA case, but I think that case has done a really good job of trying to articulate standing, trying to get through the door on the tax and spend clause analysis. The question is, I think that they may have had a problem by not looking at the rest of the tax, right? Like we talked about, they both fail to address the rest of the tax, which is like a huge broadside. And then additionally, in failing to address the entire tax structurally, have they just straight up failed the second step? And even if they have alleged it, let's look at this impetus, right? Because we're attacking the $0 tax. Okay. And so let's look at that. Let's look at the $0 tax under the functional approach. Does a $0 tax change from $200 impose an exceedingly heavy burden? I don't think so, right? I think that the registration requirements are exceedingly heavy, but that's not really relevant to a tax analysis.
Yeah, I mean, one of the problems here is
three layers deep, right? At that
point. What the law has actually done is reduce the burden on individuals,
right?
Because you don't have to pay.
Of course, they're not attacking the BBB; they're attacking the NFA,
right?
Now, subject to the BBB, but are you what are you articulating is a exceedingly heavy burden? And remember, the touchstone is 10% of a company's entire revenue, and so I think you have a hard time there. Then two, does non-payment have a scienter requirement? No, it does not. It's strict liability. If you don't pay the tax, you're out. And then it's three,
not dependent on you knowing that you violated something. It's just everybody who has these has to pay this tax.
Now there are portions of the NFA that require a knowing violation, right? But that's for criminal liability. Right now we're attacking the tax structure. And so then three, the enforcement question. Let's say we just give this one to them and say, because it's enforced by the DOJ since 2003, and revenue and the IRS is just there, in the background, kind of twiddling its thumbs, right? That it's weird. I'm not sure that you get that one. I think you have to articulate it a little more strongly. But so even argumentatively, how many of these do we have? One, maybe two. That's hard. And we can look all the way back to, Szynski, which is cited in the better of the cases, which was a tax and spend analysis that was brought by a dealer who did not pay the then $200 manufacturer's tax, right? Which is now $500 or $1,000, depending on it's the SOT. He argued in 37, this is a penalty, not a tax. And the Supreme Court rejected this, and it refused to conclude that the NFA was on its face, They were certain that the NFA was on its face a taxing measure, and they refused to conclude that it exceeded congressional power by virtue of its deterrent effect on the activities taxed. And And they kind of explained that every tax is in some way regulatory, and a tax is not less a tax because it has a regulatory effect. And this has been cited with approval repeatedly by the various courts of appeal as they've done these tax and spend laws challenges. And this is, of course, juxtaposed with the child labor tax, which was characterized as a penalty resorted to as a means of enforcing other regulation, right? Because we had already, like, through other regulation, gotten rid of child labor, but this was like a kind of backdoor way of doing it. Whereas
making
the
it
NFA tax provision is the one thing.
Right.
So it's a big challenge to bring this just because of the structure of the law.
And, speaking of those examples that you had there, one of the most, I think, obvious corollaries to this is the pistol brace ban, right? The pistol brace rule that was instituted under the ATF during the Biden administration. And that required people, essentially it reclassified all pistol braced guns as short barrel rifles or shotguns, effectively. And it said, you got to register these by X date, or else, you have an unregistered SBR SBS, which is a federal felony under the NFA. But to encourage people to register, which we know now did not work. They didn't get a lot of people to actually register their guns. But one of the mechanisms to encourage people was that they made the tax $0.
No.
System. And it was...
Wait, hold on. This is important.
Yeah. Mm-hmm.
They didn't make the tax $0. They forbeared it. They did not collect any tax.
Mm-hmm.
Right? Here, they've made it $0. So this is a $0 tax. There, they forbeared the tax. And this was problematic. And I think you're feeding me into my tax and spend challenge that I did as part of the
yes. So there was a challenge over this. You're right. They didn't change the tax. They just didn't collect it.
Right. And the law said you had to. And that was one of the bases of our tax and spend challenge, which was you are not only are you not following your own law, but by collecting no tax, there's no way that this is a proper revenue raising objective. And the government,
not a new idea here, and we have a very recent, very similar example. So what was the bottom line of what happened in that?
The government moved to dismiss our entire complaint, and everything survived except that.
So,
which was
not a good
they
sign,
said,
maybe.
The judge, who's a very, great judge, she didn't think that we had alleged the second step of a proper tax challenge. She didn't think that we had connected the structure of the law itself to the overstep of the congressional power, which was interesting because at that point the law still said shall be collected and paid. And so it's like, I still think I brought
right. You still think it was a good challenge.
A good challenge, right? Because I had also articulated that machine guns were problematic. And by the way, the machine gun question has been brought multiple times because they refuse to collect the tax. So how can it be anything but a penalty if they refuse to collect it? Which the courts every time strike down, breaking their own backs to get to early court cases, which say that there is no, it doesn't matter if the thing you're taxing is illegal, it's still okay as a tax. Because remember, where did those come from? Marijuana taxes, right?
Right, which is where all this originated from. The early drug laws were the same structure as the NFA.
Yep, all tax laws, and that's why
what the NFA is based off of. Yes,
there's tracking directly from it, and the courts 100 years ago broke their backs to let the states do this, and now we have to deal with the results, right?
So your point here, I think, largely is this not necessarily a bad avenue of challenging the NFA, but the history in court so far is not good. These are clearly difficult challenges to win, even if you think logically they make a lot of sense, or that they're good legal challenges. They have not gotten very far, and it's not new, right? This is
which, so I think that the major one, the one we're calling the NRA one, I think that one's pretty good. But I think what you have to do if you're going to bring this challenge is you have to bring it facially saying these decisions that led up to this are wrong, and just get in front of it, right? Because they are wrong, and they were reverse engineered to justify their early drug prohibition stuff. And like many things in our law, right, they're just the extended tentacles of these early failures in the New Deal era, and even before. So I think that's where you have to be if you want to bring this challenge. And I think then when you do that, you realize just how difficult it really is. Yeah.
So that I kind of transitions well into what I just want to touch briefly on, which is the second claim in that NRA, Cooper Kirk, SAF, FBC,
right.
ASA. I'll just try to make sure I include everybody.
Best friend's case.
Yes, that case has a Second Amendment challenge to the NFA as well, which also I'm just guessing here for you, but I think you probably believe that is a good challenge, but another one that we've seen a lot of, and it's had very little success, right?
Well, I don't know if I would say they've had very little success, because
okay, interesting. Yeah.
It's very clearly having an impact, right? Because sure, the NFA has been being challenged since it was first drafted, right? But post Bruin NFA challenges are fairly new.
Yeah, that's a good point. These are not the same challenges as you saw before 2022. These are based on the language in Bruin, which requires a historical analog.
For the first time, gave us a standard.
Yeah, it has a standard, and it's a historical one, which at least at first glance is fairly favorable to gun rights activists. I would think. I don't know about how well it is. The track record to this point is another question. Probably better than pre-Bruin, certainly, but not the sea change that I'm sure a lot of people were hoping for.
Yeah, because if you're in New York, right, your view of that is it is now harder for me to carry a gun, right? But if you're in other parts of the country, you're like, neat, I have hope.
Yeah. So it's. But why don't you come up the basics of what they're claiming here on the Second Amendment side, and maybe some of the recent case law you've seen?
Yeah, so it's very straightforward, right? Bruin tells you how to bring a Second Amendment challenge, and it says you have to assert that this is a regulation of an arm that is protected by a Second Amendment, and then once you've asserted that they're regulating an arm, it's on the government to show that this manner of regulating is substantially justified in the nation's text, history, and tradition. There is a lot of mud fighting right now that people believe that you've probably heard the words common use a billion times. I don't believe that they are the magic talisman that everyone else seems to think they are.
And that goes back to Heller, of course.
Yes. I don't think it's a necessary element. I think it's it's something that's helpful, but not necessary, right? Because I don't think it would be a good constitutional protection or really a fundamental rights protection at all if it only protected common expressions, right? So anyway, be that as it may, the case very clearly articulates these are what these things are. These are why they're arms. These are why they're protected. And then my favorite part of them is you have no historical justification. And that's all you have to do. You don't have to point to counterexamples. In
theory, yeah.
Well, it's great.
How some of these courts have handled it, I don't know that it's worked out quite like that. But you're right. That's how the standard is articulated in Bruin. But so here they're claiming. I mean, you mentioned this earlier, but they do kind of a rhetorical argument about
suppressed arms.
Yeah, the guns that have suppressors are the protected arms, not the suppressors themselves, I guess. We'll see what a court makes of that argument, because Now they're in the Eighth Circuit. I don't know if there have been any recent Eighth Circuit NFA silencer challenges, Second Amendment challenges there, but the Fifth Circuit has seen them just recently.
And they might be. This might just be them being once bitten, twice shy. Right after the Fifth Circuit was like, no, that's not an arm.
Yeah.
And so
feels like a response to that.
At the end of the day, it's a distinction without a difference, because if the court wanted to throw it out for that reason, they'd say, hey, the statute doesn't regulate suppressed firearms; it regulates suppressors themselves. Right. That's disingenuous and awful, but it's exactly as disingenuous and awful as saying, "Oh, that's an accessory; it's not an arm." Right. Because at that point, then what is ammunition an accessory? So I think it's a distinction without a difference. I don't think it is a magic spell that saves you.
Right.
You know what I mean? Because if they are going to say that's an accessory, it's not subject to Second Amendment protection, I feel like what you'd have to do is like, the only way to get around that would be to have one of the firearms that have a factory suppressor that's welded on and you can't take it off, right? Yeah. And just say, this is Second Amendment protected gun.
Yeah. Actually, that is maybe one of the implications of how they're arguing it. That only permanently suppressed firearms. I don't know. We'll see how the court handles that
exactly.
What things go like in oral arguments, but I don't.
They did a great job. I think they did a great job alleging the Second Amendment claim, and I think that I think it's good. I think it's good, and I think if they're going to win on a claim, it's going to be that one.
Interesting.
The interesting thing is that the GOA case spends a lot of time like teeing up for a Second Amendment challenge, and then doesn't. like they talk about in their factual allegations, there's a lot of stuff that would be prerequisite to Second Amendment challenge. It's all there.
Isn't it? But at the same time, like these are lawsuits they filed in response to this change in the NFA, right? And the second, it doesn't. I mean, I don't know, does the change in the NFA, this reduction of the tax from $200 to $0, actually have any impact on the Second Amendment claim in your view?
So here's the funny thing. Remember I said it takes a grain of difficulty off of the hill of the tax and spend challenge?
Mm-hmm.
I think it deposits that grain on the Second Amendment challenge.
Because it's less of a burden in theory, because you don't have to pay the money.
Yeah.
You know?
And again, I'm not saying, oh, you've messed up the Second Amendment challenge. It's like, I think you've moved the deck chair on the Titanic. Right. It's still there.
Yeah. I mean, you still have what they basically plead in there, which is that the registration is the burden, and people would buy these things if it weren't for the registration. I mean, that's how they get to standing, right? Essentially.
Yeah, no. And the funny thing is like, oh no, it's 30 days from now. And this person would buy it within 30 days of January 1.
Right.
Which is all funny, like lawyer, like chess stuff.
Because the law doesn't actually go into effect until January. But that was actually another one of my questions. Is like, I was wondering if, because there was a delay, obviously, from when the GOA suit came in and when the NRA Kirk one came in, and I thought, well, maybe they're waiting for the law to go into effect, but nope. I guess they figured this was good enough. They could just say,
yeah. I'm not sure if GOA has articulated any type of standing. And that said, I think they should have. I think this should be enough. I don't think it is, though. You know what I'm saying?
Yeah. So you see some weaknesses in the actual filing, not necessarily the concept, standing logic.
Yeah, like because their injury articulation is that they don't want to do the paperwork.
Right.
Which I sympathize with. I do not want to do the paperwork.
Right.
And I think that would be very relevant for a Second Amendment challenge. I'm not sure that that's a concrete and particularized injury for a tax and spend challenge.
So there's a different standard there.
It's have you articulated a injury that's traceable to claim you're bringing, right? I think it's very traceable for a Second Amendment argument. I think it should be traceable for a tax and spend argument. I don't know if the court is going to agree, right? Like all of these arguments make sense to me. They make perfect logical sense.
Sure. But
remember,
that's not the standard here. Yeah.
Yeah. The logic is not the standard. It's,
because you can certainly read through this. And this is a common issue, I think, for reporters like myself, where it's very easy for me to read through these filings and
you're like, oh, it makes perfect sense.
Yeah, it makes sense. And I think that a lot of people, a lot of laymen, that's how you would approach it.
And then the court yells at them. You're like, why did you do that?
Yeah, if you don't have the expertise in the topic and in court procedure and the case law, you're only getting the plaintiff's view of what the argument should be. And so it's very easy to just, it makes sense. It's logical. It makes sense.
This
What
is
you're
an
saying here, but that's why you got to scrutinize these things.
It's an old trial lawyer joke. Can you see my hand?
Yes.
No, you can't. You've only seen the prima facie, the first side.
Yeah. So, it's why it's important to have guys like you on the show.
To just pee on the parade.
Well, just to give some additional context as to how these things have gone, and that's why it's important to have resources like the Reload, where I can understand the logic, I could even agree with it, but also I'm aware that other of the context here, maybe I'm not as aware of tax law as someone like yourself, and I'm sure there are other people out there who are even more, have dedicated their whole life to doing tax law stuff.
God bless them.
That are better informed on the topic than we are. But the point is, like, you got to be able to have that extra layer of context, or else every lawsuit you read is going to probably sound, not every single one, but there's some real trash ones out there. But, a lot of them are going to sound persuasive on first read, right?
Right. Which is the job of an advocate, right? But
that's what you're doing. But
I do think there are problems with one of these filings is like wildly problematic. The other one, it's like, it might be all right. And no one's perfect, but I do think that kind of the way these suits happened, I think it's more a problem with the state of gun rights advocacy as it is now, where, and you and I have talked about this a few times, and I get a lot of flack for saying this, but this is my sincere belief. I think the biggest problem that we have is because, like we were talking about, we've got to be fed that this big red button is going to be pushed and blah, blah, blah for so long that everything has to be either epic win or big loss, right? Like there's no room for gray, according to, most gun rights advocates. It's either Supreme Court is on fire, Biden is crying, eating ice cream, or like we did it, NFA is overturned. When in reality, fighting for gun rights, which, really Stephen Halbrook created as a field of study, like a few decades ago, is all about incremental movements of the needle. That doesn't mean we shouldn't try really hard to knock down the big pins, but I think you're going to get really exhausted if everyone's always saying, look, we're going to knock over the big pin. And for 10 or 20 or 30 years, they've plucked a few blades of grass, but you're just looking at the pin,
Yeah, I mean, it goes back to that definitely mirrors what my thoughts during the legislative fight over this, where it was like, I get the attempt here to do delisting, right? I get it's worth taking a swing. When you're not going to get a better shot at it than what they tried to do in the most recent reconciliation bill. But you have to understand the reality of that it is it was a high hurdle to clear, that there are reasons, not just like, the deep state is trying to block this type reasons, but like real reasons, for why this might not make it through the reconciliation process.
Yes, they're not good reasons, but, from a moral perspective, and
sure, they might not be, right?
Perspective.
They
but
may
they're practical.
Yeah, and then they go back to, like, you got to understand how the Senate works, how the reconciliation process works, why this is a long shot to get through. And oftentimes advocates will flatten out all that stuff and just say it's obvious that we're right, and anyone who disagrees with us is going to be because they are a partisan hack or what, what I mean? Like,
let me stress again, because
it's a high bar, but it was worth the shot, given the situation. It didn't work as far as the delisting goes, but you did get a substantial movement there that hadn't happened in any reconciliation before this one, and then yet it was still treated like a big failure.
No, I literally called let me make this clear before I say this, because I feel like every time I come on here and try to be nuanced, I get death threats. I think that the NFA is completely categorically unconstitutional. I think that all gun laws are infringements. I think you should be able to buy an AK-74 from a vending machine. That said, I do not think that getting the making and transfer tax reduced to $0 was a tremendous failure and unbelievable betrayal by whoever that, you know. I think that I'm able to see that this is the first time we've gotten something back from the only other time was PLACA, which is for the industry. It wasn't, I mean, you know, it trickles down to us, right? But
And that was 20 years
when was
ago.
the last time we got something back?
Yeah. No, that's a legitimate point. And look, you know, it's not to say that getting the tax on transfers and making for a couple of NFA items to $0 is, you know, some grand thing, but it is substantial in the context. Like, you got to understand how Congress works, what the national context on gun politics has been for the last 20 plus years. It hasn't been moving away from restrictions. And so, while I understand people wanted more, and I think they were misled about what was really possible or what was likely to happen, by a lot of other, by the kind of people you were describing earlier, just like all or nothing, screaming,
big win.
Yeah. Like, but, you know, so that's why we do what we do right here at the Reload. It's just like try to give you some context. And it's the same thing with these cases. Like, it's not to say that they're going to lose.
These are the tremendous challenges that they're facing. By the way, the challenges that people have been facing tremendously for almost 100 years.
Yeah. Like, you got to understand the context. You got to understand what the hurdles are here, what the strengths and weaknesses of the arguments are, or you're going to be shocked every time some piece of news comes out, right? That's the thing. Like, anybody who was following the Reload was not shocked by how things turned out in this NFA fight in Congress. A lot of other people were, and they were just totally taken off guard.
Betrayed. They legitimately felt attacked, which is just.
Yeah. And look, it's fine to to judge Republicans on how they went about, you know, maybe they didn't use the most aggressive tactics that were possible, but you should understand going in why that was unlikely to happen. And to just, so like, it's just about being informed, I think, at the end of the day, and trying to, you know, going to the gun rights groups. They serve their purpose. They're the activist groups. They you know, are trying to reach the goals that they have. They're trying to raise money for the missions that they're on. And that produces a number of incentives that don't necessarily align all the time with with them giving you the most accurate possible information on what's happening or the full context of what's going on. It's not to say that you should ignore their voice, or like, we have gun rights groups and gun control activists on the show all the time, because our goal here at the Reload, right, is to give people the best understanding of what's happening, not to do advocacy.
And that's not to say that
point of view is.
And let me also point out that the things that I complain about in advocacy groups doesn't mean that I want to see them abolished. Right? I continue to work with them. I continue to work with some of the people we're talking about right now. I think you and I just really care about the truth, and so the universe is
we
make
are
sure that we're
heroes. In other words,
you're what?
Martyrs. We are heroes and martyrs for the truth here on this podcast. But so I think it is important to look at these things and with a skeptical eye and understand what the background of how these challenges have gone, what the difficulties are, why these cases might not win. They may win, right? We're not saying here that that they're doomed from the start. It's just that there are real hurdles to overcome. I'm glad that you were able to come on and give us some insight into those, as somebody who both is not directly employed by any of the groups involved here and has fought these exact kinds of challenges before. I think that's provided people,
and we will continue to do it in the future.
Useful information. Yes, absolutely. And we will have to have you on again. Maybe next time we will talk about a case that you're directly involved in, or maybe I'll have another gun rights lawyer on to talk about a case that you filed in the future, so that you can get that full experience.
What an idiot I am.
That the lawyers involved in these cases got today. But yes, no, we appreciate you coming on. For anyone who wants to keep following your writing or speak, I guess you're mostly talking, right, on the show. what's the best way they can do that?
You can go on the YouTube channel, Fudbusters. There's also Fud Blasters if you want to see actual hands-on firearms content. The best way to be directly in touch with me and my work is to support me on Patreon. You can have access to our Discord, where we very often are talking about these types of problems, and it's really stimulating to talk to other people who actually care about this type of stuff, and it keeps me alive. So that's pretty cool.
There you go. All right. Well, I appreciate you joining again. We'll have you on down the line to discuss more of this as these cases develop and other cases come up. But appreciate you doing this. And that's all we've got for you guys this week. We will see you again real soon.